share your questions in the chat box, or you can send me an email and I will share your questions with the speaker afterwards. Thank you again for joining. Sorry for 5 minutes late. We had a technical difficulty, and I will now hand over to Aurore to start the session. Thank you very much.
Good morning, and thank you, Leila, for the introduction. As Leila said, today during our session, we will discuss how to grow and protect your brand in the Middle East and the GCC. First of all, we would like to highlight the difference between copyright, trademark, and trade name. And then, while defining a brand, we will highlight the importance of having a branding strategy and how to select a trademark. Once the trademark is selected and your branding strategy is set up, it's very important to protect your trademark. How to protect it? The protection would be by filing and registration the trademark before the relevant authorities, by monitoring your brand in the market, and by using legal actions on infringement and unfair competition. Also, it's very important to protect your trademark under distribution, franchise, and license agreements. You can see we have different types of IP rights, trademarks. Sorry. You can see we have different types of IP rights, trademarks, patents, copyrights, industrial designs, and industrial designs. However, we will focus on the trademarks because it's most important assets of a business and a company. And we would like to highlight that the industrial designs usually in practice, we register them under 3-dimensional trademarks. It's possible to register them at industrial designs. However, not all the countries in the GCC and the Middle East have such law. Recently in Qatar, they issued the law for industrial designs. Before, they used to register it under the as a 3-dimensional trademarks. What is the difference between copyrights, trade name, and trademark? We will start with the trademark, with the copyright. The copyright applies to a wide range of creative, intellectual, artistic work, softwares, mobile applications. It does not cover information and ideas. However, it covers the form and the mean in which they are expressed. As a distinction with a trademark, the copyright gains protections from the date of its publication, and the author will gain the exclusive right to use, distribute, and publish such work. However, for the trademark, most of the countries are first to file, and the trademark will gain the protections from the date it's filed, once registered, of course. For the copyright, it's not mandatory to register a copyright. However, it's highly recommended to use it as evidence in the case of dispute between two authors. Some countries in the GCC, they do not have copyright registration mode, such as Saudi Arabia. In such case, we recommend you to keep all your records, all your emails, the receipts, the first draft for any copyright work, maybe the emails, the conversations with your editor, with the publisher. You should keep them in a file in order, if there is any dispute with another author, you will be able to prove and evidence your ownership. The copyright is granted, the copyright protection is granted during the lifetime of the author and for 50 years after the death. What about trade name? Trade names, a trade name is a name under which a business is conducted. It could be the same name of the company as registered in the deed of incorporation, and it could be another name. It can be descriptive, and this is a distinction with trademark, as a trademark cannot be descriptive. While the trade name identifies a company or a business, the trademark identifies goods or services provided by such company. For example, as a trade name, we have the Coca-Cola company. The trademark would be Coca-Cola. Another example for in Qatar, the telecommunication company of Qatar. This is the company name. However, it's known in the market as Ooredoo. Ooredoo, at the same time, it's the name of the company, and it is registered, and it gained the protection of a trademark and became the trademark of the company. You should take into consideration that you need to choose a reliable trade name. You should avoid some issues, and you should avoid naming issues by taking the following steps. Avoid unusual spelling. Do a Google research to check if there is anyone else who took the name or is using it as trademark. Do an official research with trademark office in the country you are wishing to establish your company. Think about international implications of the chosen name. Does it have a negative connotation? Is it embarrassing? And come up with 5 names you like and test them in the market while approaching prospective consumers, investors, partners, employees, and make sure the name is distinctive, memorable, and not limiting. What about the protection of a trade name? The trade name gained the protection from the use and not from the registration. And this is a distinctive thing from the trademark. While it's defined, it serves to define the official company name. It makes it legal for the company to enter into contracts and participate in other legal forms and businesses. The trademark, the company cannot use the trademark to enter into contracts. You need to use your trade name on your websites and your letterhead in a noticeable way. And you should take into consideration that the protection of a trade name, it is for the same sector and the same geographical area. What does this mean? For example, if I'm going to establish a company in Qatar for food and beverage management, this is the activity. I choose the name X. I book the name for the activity food and beverage operation and management. If someone else come to register and establish a company for the same activity, food and beverage, he cannot use the same name. However, if he wants to establish a construction company, he might be able to use the same name, subject not to cause confusion. When he will cause confusion, if, for example, it's very well-known trade name, it's an international company, and maybe this company has many sectors, not only food and beverage, he might be able to oppose on such incorporation. But in general, he might be able to register with the same name because it's a different sector. What about the geographical area? I will give an example for Lebanon. In Lebanon, we have different commercial registrars in different areas. For example, we have in the north of Lebanon and we have in the south of Lebanon. If a company is registered with a commercial registrar in the north of Lebanon and another one with the same activities in the south, if the customers of the company in the north, even if the company in the north have a website, the website does not grant this company or the trade name a protection nationwide. Why? Because we need to check the consumer and the customers of the company. If the customers of the company are from the same area, from the north of Lebanon, then the protection will be granted for the north. And the company established in the south, if the customers of this company, they are only from the south, then They will be able to have the same name, and because they are in different geographical area. Now we will talk about the importance of branding and having a strong branding strategy. What does branding mean? Branding is a marketing strategy. The importance of having a strong branding strategy is because this strategy will make people identify your products and associate them with your organization. And an effective brand strategy gives you an edge in increasingly competitive markets. It helps them select the product over the competitor products. Before setting up your marketing strategy, there are a set of questions that you need to answer. What is your message? What does the customer knows about your company? What are the qualities you need to associate with your products? To whom you are addressing the trademark? Where you are launching your trademark? In which geographical area? When? Is it in the summer or the winter? And how you will advertise for it? To answer the questions, what? You need to conduct a survey. Don't save time and don't save money. Don't do this mistake. And never rely on what you think you know about your customers. You need to conduct a survey to know what are the needs, what are the habits, and what is the culture of your customers and prospective customers. Where? It's very important to know the location. It's very important to know the location where you are launching the trademark. In which country? Do a market research, and this is a key investment for companies and startups in the GCC. It allows effective targeting and filtering for the segmentation, as well as the ability to compete successfully. You should take into consideration that you cannot look into the GCC as a whole market. You should divide the countries, you should divide the marketplace into countries or into major cities like Dubai, Abu Dhabi, Doha, Riyadh, Jeddah, to explore the demographics of expats, density versus locals, and the competition and the market needs. For example, the expats dominate cities like Dubai, where you will have to rely on English content. Saudi Arabia has the lowest number of expats in the GCC. However, the purchasing power differs from city to another. So also in the Saudi Arabia, you cannot take the Saudi Arabia as a whole market. You should target cities. To whom? You should know the personality of your customers. In the GCC, it's very important to know that purchasing decisions is highly influenced by family and community. Although they are interested in current trend, but they are highly influenced by the community and the family and their decision of how they see the things. So the brand image should address the Gulf culture. And you should know that Middle East and GCC consumers are not fast movers. They are slow. They go slow to ideas. They wait until they see the high demand in their community until they go and purchase a product. Now, how to advertise to your trademark and your brand? You need to avoid the translation and work on native content as a first step. Then simplify your marketing message to be able for the local consumer to be able to be attracted to it. It's advisable that the brand image and the marketing strategy address a message aligned with the Gulf culture and not to be creative. Be simple. For example, automotive brands, they tend to focus on luxurious specification with a desert in the background as a theme. Beauty, they focus on the black hair, which is a specification of Gulf women and Arabic women. So to match the Arabic beauty. Also, fast food, they always adjust their meals to match the local taste. So as we can see here that a consistent strategic branding will give you a strong brand equity, and this will bring an added value to your company, and you will be able to charge more for your product than any other similar product in the market. Now you set it up, your branding strategy. It's the time to define your brand and to choose your brand. There's key points you need to take into consideration while choosing your brand and defining your brand. You should get a great logo. Place the logo everywhere, on your letterheads, on the signboard, on your business card, just to see how it will look and how it will be seen by others, by customers, by employees. Conduct a survey within the company to see how it would be the impact. And the logo, it has to be simple, appropriate, and unique. Write down the brand messaging. What are the key messages you want to communicate with for your brand and with the customers? Integrate your brand in every aspect of your business. How to dress, how to reply to an email, this e-signature, the business card, everything. Develop a tagline to attract the consumer. One of the famous taglines, it's McDonald's, I'm loving it. Design the template and create the brand standards. Choose your colors for the brand. The colors are very important because every color has a message, and be consistent. If you cannot do this, you will fail to attempt to have a strong brand. What about the selection of the trademark? First of all, you need to know that the law prohibits a list of marks or signs that cannot be registered. Signs which are not distinctive, signs which are descriptive. Any term, design, contrary to the morality, public order, Sharia law, or has any religious connotation, any official sign cannot be, or public emblems, flags cannot be registered. Symbols which are identical or similar to the Red Cross and Red Crescent cannot be registered. Also, signs likely to deceive the public or which contain false details to the origin or the characteristics of the goods or services. Any signs or terms which are identical or confusingly similar to the public to a mark already registered for which application was filed by a third party for identical or similar goods or services. Those are restricted. Now you know what are the restrictions. You need to disregard them and now to choose and to think about your trademark. You have different types of categories. You have the fanciful or arbitrary trademark. You have the suggestive, the descriptive, and the generic marks. You need to avoid, while selecting a trademark, you need to avoid the likelihood of confusion with other marks. You need to select a strong mark in the legal sense. You need to avoid animal or plant names, and you need to avoid describing an experience. Which are the strongest in the legal sense and which are the lowest or the weak selections? The strong selections are the fanciful and the arbitrary trademarks. Generic mark and descriptive mark are the weakest. What about generic mark? Generic mark, they are common in everyday use to describe the particular class or variety of which the good is member of or served. For example, using the term car for automobile. this cannot be registered as a trademark. Otherwise, you will be unfairly prohibiting other parties from using the same word for automobile sales. Also, you cannot use the term cafe or restaurant to register as a trademark for a food and beverage store. This will unfairly prohibit others from using it. However, we can combine this generic term with another word, which will, and it could be registered as a trademark then. The whole term will be protected. However, you will not be, you shall waive the term, the exclusivity on using the term cafe, for example, or car, separately. For example, Café Del Mar. Café Del Mar, you can register it as a trademark. However, the trademark office will, as a condition, will let you waive the exclusivity on the term cafe if used separately by another person. Also, do not think about adding a suffix to the generic term like .com, .org, .net. This is not acceptable and it will be rejected. Hotels.com, they did not, they tried to register it as a trademark and it was rejected. Also mattress.com, it was rejected. Why it was rejected? Because they considered that this is a generic term for any online store selling mattress and bedding. So you cannot have an exclusivity on it. What about the descriptive mark? The descriptive mark is the term used to describe the ingredients of the product or service. It used to describe the smell, the color. For example, soft to describe the towels, cold and creamy for ice cream, or sunway for sunscreen, or cool and breezy for air conditioners. A mark which is only descriptive usually cannot be registered as a trademark. It will be rejected. However, some countries may consider it as a trademark if used for a period of time, for a certain period of time. Some countries for 5 years, others for 4 years. If this descriptive mark is used for successive 4 or 5 years, it might elevate to the level of a trademark. But you need to take into consideration that if you choose a descriptive mark, and which is, by the way, this is the marketing professional, they love it. They always use the descriptive because they consider it as fast to reach the consumer and they will be attracted more to it. But the company will have to take into consideration, if they choose a descriptive mark, they will have to invest a lot of money, a lot of effort, and they will need a lot of time to polish the mark in the commerce and to elevate it to reach the level of a trademark. So we do not recommend to choose a descriptive mark because this will be very costly for you, and try to avoid it. You can always combine the descriptive or the logo, for example, which will enhance the trademark. The fanciful trademarks, which is the strongest one, this is only created. It's completely unique. You have, for example, Kodak and Xerox. The arbitrary trademarks, the terms already exist. They are not created, but however, they are used arbitrarily. One of the most, or the example, the famous example, it's Apple. Apple is a fruit. However, it was registered for devices, and this is an arbitrary use. Shell also. Shell, it's an arbitrary use on the products which were selected. So these are the strongest types. We have another type which is in between, the suggestive marks. Suggestive mark, it's a link between the brand and this form of trademark. It requires an imagination from the part of the consumer. For example, of the suggestive trademarks. Microsoft. This is a combination of two words, microcomputers and softwares. KitchenAid. They attend, or you can say that it is machines that aid in the kitchen. So it's a combined word between two words, Microsoft, microcomputing softwares. I can say, for example, Greyhound. Also, it's a combination of two words. The difference from the descriptive mark is that the suggestive mark will leave it for the consumer to analyze and check what would it mean, what does the word mean. Next, in our slide, we will talk about the protection of a trademark. It's very important and crucial for a business to protect the trademark by filing it and registration on a national level. Why on a national level? Because we do not have in the GCC and Arab countries any regional protection like the EU. Also, not all the countries are first to use. Most of Arab countries are first to file. What does this mean, first to file? First to file, that means the first one who filed the trademark, he will be granted the protection, with an exception of Lebanon, which is a first to use country. Also in UAE, there were several court decisions where the court decided that the registration of trademark is a legal presumption for ownership, and the opposite may be proven. Therefore, there are 3 steps to the protection: the filing, registration. Once the trademark is registered, it's protected, and the owner will be granted the exclusive right to use it. Now, what about the process of filing and registration? First of all, you need to select the classes you need to cover by your registration very wisely and very carefully. We have 45 classes that cover all the goods and the services. You have to select them very carefully. You cannot register under the whole 45. This will cost you a lot of money and a lot of time. And it's useless because most of the businesses or companies, they like to protect their product. They like to protect the trademarks for the products they are targeting. And you need to make sure not to miss any class or any good which is covered by your trademark. Why? Because if you missed it, you will risk losing the right to use such class. And if someone else would like to register under this class you missed, you will not be able to object probably. You need to take into consideration while choosing your classes and your goods that in the GCC countries, it's not possible to register for alcohol or co-products or bars. Those are prohibited. Also, a note that a well-known trademark, even if it's not filed and registered, if it's a well-known trademark in the territory, they will be able to be protected without registration. However, the protection, the well-known should be evidences. It should be provided by evidences like flyers, advertising, sales charts that would be presented to the court, and the court will have a discretionary power to decide if this trademark is well-known or not. So although if you consider your trademark a well-known trademark, try to register it because the power, it says for the discretionary power of the judge to decide on it. The owner of the trademark or his attorney will submit a filing application for the trademark. Most of the GCC countries and Arab countries, they do not have multiple classes application, with an exception of a few of them, like Morocco, Algeria, Lebanon, for example. We do have multiple class application. As well, you need to consider that each aspect of your trademark needs to be submitted in a separate application. Once the filing fees are settled, the trademark office will examine the trademark to see if it's acceptable or not. If it is acceptable, then we need to settle the publication fees and it will be published in the official gazette. Some countries, the publication will be after the registration, like in Lebanon. We settle the fees, the filing fees, registration fees, and the certificate will be issued upon the acceptance of the trademark office. However, in general, in most of the GCC countries, it is like this. We settle the publication fees, we publish in the official gazette, and then it will be published for a certain period of time, while a third party, any interested party, can oppose the registration. We have the opposition system. The period depends on the country. For example, in UAE, it's 1 month. From the publication date, any third party may oppose the registration of the trademark within 1 month from the publication. In Qatar, it's 4 months. In Morocco, it's 2 months, for example. Lebanon and Algeria will not have the opposition system. It's directly, if there is any infringing, that we can file a cancellation action after the registration. If no opposition, then we will settle the registration fees and the certificate will be issued. If an opposition was submitted by a third party, the opposition will be notified to the applicant, he will submit a counterclaim, and the trademark office will decide on this, we will have the final decision for the chief of the trademark office. However, his decision can always be appealed before the Tribunal of Commerce. If the trademark is registered, then the protection will be granted for 10 years from the filing date, with an exception of Lebanon and Saudi Arabia, where the protection is for 15 years from the filing date. Now, we would like to highlight some special process for filing FIFA IP rights in Qatar. We all know that the World Cup in Qatar, the 2022, is in Qatar, and FIFA had to impose or to try to amend the law. They tried to amend the law, however, they issued a special law for the FIFA, only for the trademark of FIFA. We still have the law number 9/2002, which is applicable on every other trademarks. And law number 11/2021 will be only applicable on FIFA IP rights. The main differences between the two laws, that first of all, regarding a license agreement, any other trademark, there is no specific deadline to register the license. So the law does not provide a deadline for the trademark office to register a license agreement. However, for the FIFA, if any license agreement, it should be registered within 15 days from the application date. Under the normal situation, the license agreement should abide to many formalities. For the FIFA, the only formality it should be written. It should be a written agreement. There is no other formalities. Also, for filing and registering a trademark, under the normal situation, filing and registration a trademark, it will take from 5 to 8 months in practice. However, for the FIFA, it will take 15 days from filing to registration, all in all. Trademark office for FIFA IP rights, it's not allowed to reject the brand's registration. He cannot reject it. However, under the normal situation, he will examine the trademark. He doesn't have a deadline for the examination, how long it takes. Usually it takes 1 month. And then he might be able to reject or accept the trademark. For the FIFA IP rights, he cannot do this. The opposition under the normal situation is 4 months. However, for the FIFA, it's 15 days if someone would like to oppose. And the trademark office will have to decide on the opposition within a very short term. However, in normal situation, there is no deadline to decide on the opposition. Now, the trademark registered, it's not only about the registration to protect your trademark, you need to consider monitoring your brand in the market. You should monitor it in the market. Also, you should monitor your competitors in the market. And the best tool to monitor is the media monitoring. It helps you to see what people think about your brand. Are they aware about your brand existing? Do they understand your brand? And it enables you to spot any false impression you can take action immediately to correct them. What about monitoring your competitors? It's very important to monitor, to watch them and to monitor your competitors. It allows you to see what is coming and to plan your strategy on this basis. It lets you discover what they are doing and analyze the actions. For better result in the GCC, use Arabic language focused on social media analytics, social media monitoring tools, which allows you to monitor mentions of your brand, get competitive intelligence, track relevant hashtags, analyze keywords, and discover trending topics. Also, you need to watch for possible infringing marks. How to do it? Engage experts in providing watching services. Such expert will have access to a wide data from multiple trademark office and official gazette that allow you to detect any early infringement and to stop it earlier. Provide training to your staff about your trademark. Let them know your trademark very well, and to be able to target any infringement or any possible infringement in the market. Conduct market investigation, whether by engaging third parties or by your representative or staff. However, please take into consideration that in the Arab countries, GCC, Middle East, we do not have private investigators. The market investigation, we do it to know, for our knowledge, to know the source of infringement, if we can know it, to be able to send a cease and desist letter before going to court, to be able to negotiate, and if the cease and desist letter does not reach our target, then we will have to go to court, and then we will know the offender against whom we will file a complaint. This is why we do market investigation. You should register your trademark with the customs to avoid the entry of any infringing products. As I said, watching third parties' applications provide you an early detection to stop and enforce your IP rights. This will avoid paying a lot of money, because if you miss the deadline, you will always be able to file a cancellation action before the Tribunal of Commerce. However, this will cost you a lot of money and time. This will lead us to the infringement and unfair competition cases. The GCC trademark law does not express very clearly what is referred to trademark infringement as other jurisdictions. It only set out penalties against any forgery, counterfeiting, or imitation of trademarks. Although this wording leads you to think that it's all the complaint will be only directed against direct counterfeit or imitation, like the lookalike, trade dress cases involving. However, in practice, you can file against any suspected infringing act. and we can always analyze the text and use other precedents from other jurisdictions, Roman-Germanic systems like France, Egypt. The acts, the infringement acts, are anyone who forges a trademark which was registered or imitate the same in a manner which mislead the public, anyone who affixes in bad faith on goods or uses in relation to services a trademark owned by others, also anyone who sells or trade or possess for selling goods bearing a forged or imitated trademark. To go to court, you have for the infringement cases two options: criminal complaint and a civil complaint. Criminal complaint, usually we opt for the criminal complaint when we do not know the offender. Why? Because the police will get the evidence, will be leading the investigation, and the public prosecutor on behalf of the state will be leading the case. But you cannot only file a complaint, a criminal complaint alone. You should always think about filing a civil case associated to the criminal case to be able to allow the criminal court to award you a compensation for the damages incurred. The difference with a civil complaint, that the civil complaint, you have the leadership on your file. You are the master of your file. You will be handling and you will be able to provide all your evidences regarding your ownership and the infringement product. We opt for the civil case alone when we know the offender. So it's for us easier to go and file it against the offender and ask for the cancellation of the infringing trademark registration if it was registered, to ask for compensation, and to request the court to order to remove and destroy all the counterfeited product from the market. Something to take into consideration that in our systems, we do not have specialized court in intellectual property. UAE issued a notification for establishing the specialized court. Until they will be fully operated, the courts will be looking into infringement or IP right cases. They will be the general civil courts, the Chamber of Commerce. And we, as I said, we do not have binding precedent system. However, we can always support our case with similar precedents from jurisdictions like Egypt, Saudi Arabia, France, to support our case. It will be taken into consideration. Now, how about the unfair competition? The unfair competition is usually known that it is resorting to court to protect an unregistered trademark. Usually it is like this. And in many cases, this was confirmed. Also in UAE, they said that the unfair competition is a mean to protect unregistered trademark. And they confirmed that the registration for the trademark is a legal presumption, as we said, for the registration, and can be proved, the opposite can be proven. However, we do not have a special text for unfair competition. We always resort to other texts to define the unfair competition. We resort to the commercial law, the relevant provisions of anti-commercial fraud law, anti-cyber law, and the Paris Convention. We leave to the precedents, to the courts and the scholars to define the unfair competition. The courts have set 3 criteria for an unfair competition act. You should have a competition status between 2 parties. The commission of an act of unfair competition, which is defined as a professional mistake made in search for unfair profit in violation of the legal and moral principles of the market, of the commerce. And It's very important to incur damage. You should suffer from injury and damages to be able to fight in unfair competition. Lebanese scholars define the unfair competition as creating confusion in the mind of the consumer, creating disorder in the market, and defamation. In our last slides, we would like to highlight the importance of protecting your brand while entering into some trademark or IP agreements like distribution, franchise, and license agreement. Under a franchise agreement, it's very important to include in your agreement the modality of usage of the franchisor trademark. It should be clearly set. If the use of such trademark is not properly managed, the franchisor could face some serious reputational damage. You should consider including some clauses in the franchise agreement. The franchisee acknowledging the ownership of the franchisor's trademark. An undertaking from the franchisee that all the products shall be sourced from a verified third party or from the franchisor itself. Any unauthorized use or modification of the trademark or the sale of third party without prior written approval from the franchisor may result into the termination and the repudiation of the franchise agreement. Forbid the franchisee from registering your trademark under his name, and take an undertaking from the franchisee to assist you as a franchisor in monitoring your brand in the market and in the territory. Consider registering your trademark in the relevant territories and registering your franchise agreement before the relevant authorities, while including in the appointment letter that it's prohibited for the franchisee to register the trademark under his name. Why we are stressing on this and why we are highlighting this? Because in practice, many distributors, franchisee, licensee, they benefit from the agreement, and there is no prohibition to register the trademark under their name, and they benefit from the lack of registration from the principal, the owner of the trademark, and they go and register the trademark under their name, and they tell the franchisor or the principal that it's, or they tell the government that we are registering it to protect it, and the contract does not prohibit us. And many jurisdictions accept this, and then disputes will arise between the two parties. So to avoid this, put them in the contract and consider registering before entering into the agreement. The same applies to the distribution agreement. Consider registering in the concerned territory before entering into a distribution agreement. You should consider also to be active, to include in the contract to be actively involved in the marketing and advertising of branded goods. Such activities certainly impact upon the goodwill or reputation associated with your branded product. So be actively involved in this. Also, consider that upon the termination of the agreement, you should, as trademark owner, you should get back all the rights and goodwill associated with the trademark during the course of the distribution relationship. Also, during the term of the distribution agreement, the owner of the trademark should ensure that the distributor respects the stipulated manner or use of the trademarks, maintains the quality associated with the branded goods, and identifies itself as authorized distributor, licensee to use the trademark. It's very important to put it in the trademark, in the distribution agreement. Finally, regarding the license agreement, before entering into a license agreement, always think and ask yourself, do you have a manual or criteria to deal with infringers, third-party infringers? Do you have any criteria for dealing with the breaches and infringements from the licensee itself? Consider if you have them. If you don't, try to put a brochure, bullet points about it, and train your staff and train your licensee about such manual and criteria to know how to deal. For example, third-party infringers. Do you have, if you don't have a manual, think about having some bullet points. Some of the licensors, for example, they do not like to go directly to courts. They will probably tell the licensee if there is any infringement, we would like first to send a cease and desist letter to try to approach them to stop any infringement. If they do not stop the infringement, then we will talk and maybe we'll go to court. But usually, most of them, they like to approach first by a cease and desist letter. Putting such manual and criteria and notifying the licensee with and training it to do it will save you lots of problems and money. You need to consider including some clauses in the license agreement. For example, is there any room for the licensee creativity in terms of products or services during the term of the agreement? If so, what would be the process and who would be the ultimate owners of such creative work? The licensor may have the right to install a management team into the licensee operations as well to allow the licensee to improve or instruct the management in the proper operation of the license. Think about including insurance clauses. Insurance clauses to protect the licensor in the event the goods or services provided by the licensee are defective, or if the licensee incur any kind of liability during the term of the agreement. Try to include the business interruption insurance. If the licensee interrupts his business, then the licensor, for whatever reason, he will keep having income during the interrupted period. Also, think about setting out the respective rights and obligations of the licensee of trademark and the licensor when it comes to litigation. Who will be in charge of the cost? Who will be in charge of appointing an attorney? And if any damage, who will be, or settlement award, who will be in charge of getting such settlement? Thank you for your attention.
Thank you, Aurore, for delivering today's course on growing and protection of your brand in GCC. It was very interesting. Thank you all for attending today's webinar. If you have comments, feedback, or questions, as mentioned previously, you can submit your questions to me by email. So please do not hesitate to contact me if you have any feedback. LexisNexis Maurice was very pleased to have you today and wishes you all a good day, and we'll be delighted to see you at one of our upcoming courses or online training sessions. Thank you again. Bye. Have a good day.